Division bench item 1 for pronouncement of judgment. Sitting singly. Through remote VC.
John, for quite a long time.
Your Lordship,
Just wait. We don't know whether we'll reach there or not, but let us.
Lordship, the learned senior counsel is out of session and I have given the adjournment slip yesterday itself
Please given.
because it's an association matter.
Okay. Okay, item 9, all sides are represented. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after a week.
Should make it 2 weeks because he most probably he won't take the matter.
Huh?
He has asked me to collect the brief from him and most probably a new advocate has to be engaged, the senior counsel. The president is
2
from
weeks.
Tinsukia. Oblige.
Okay.
Oblige you.
Wait, please, your lordship. Lordship, I beg to mention, lordship, item number 8, lordship. Yesterday, I have given the slip, lordship, for 2 weeks' time for adjournment, lordship.
2 weeks. All sides are represented. Okay.
Highly blessed.
May I please, your lordship? Lordship, I beg to mention item number 7. So my senior Mr. Yudutta is not available because of his personal leave. Lordship,
Okay. 2 weeks.
unlike this.
Item number 1 for orders.
In this case, we could file the affidavit only yesterday because the report was submitted finally on.
We have got it. We have received it, my lord. We are ready.
Does it come on
We-
record?
I don't think it has come on again. And one more thing, lordship, in the report, we could not annex all the annexes because these were in vernacular. So we have submitted one copy to the other side also of the annexers, but we'd like to translate it and put it in proper format, lordship. Because of the paucity of time, because last 3 weeks, lordship, in the neighboring district, there was large scale violence and all the police and the magistrates were all stationed on the border. That's why there is a delay. We could not fulfill our commitment regarding filing of the affidavit at least 1 week earlier. Lordship know what is the situation there. Translation? Nine. No.
From our side, my lord, we had virtually finished our arguments. Only a small part remains now because of the affidavits filed by them. Short, very short.
But if they want to file documents,
A lot of handwritten documents are there. We have to type it and type the annexers.
Yeah, he was given a long time. In fact, your lordship gave extra time so that it would not be adjourned. We are very anxious that an independent investigation start. I leave it to your lordship, but we are very anxious that an independent investigation start into
they
the
did by
killings.
28,
28, Lordship.
do it at least 2 days prior to that.
Yes, Lordship. We'll do it in 3-4 days. We'll
Mr. Gonzalez, we are fixing out 28.
Grateful, my lord. Yes. We'll take a short while and finish on that date.
put it on 29th, Lordship. 29th,
29th.
29th, next day.
That is motion day.
You don't have my calendar.
Okay, let us
Amlal.
Third of
let us start on that day, 29th.
29th, Lordship.
How many times? Keep the calendar. Keep the calendar. Sir, 28th is little better
29th.
for me than 29th. 28th is little better if my learned friends can accommodate.
Actually, I'm reaching Guwahati late night on that from a foreign trip, Lordship.
Okay, my lord, 29th. Grateful.
Mr. Colin Gonzalez, learned senior counsel, is present through video conferencing, assisted by Ms. D. Ghosh, learned counsel for the petitioner. Next, Mr. D. Saikia, learned advocate general, assisted by Mr. D. Nath, learned senior committee advocate. Has prayed for some more time to file translate copy of documents which could not be annexed to the state's affidavit filed on 18/11/2024. Post office is also submitted that in the border areas of Barak Valley, there was some disturbance for which the police personnel were engaged in law and order duty, and there was some delay in filing of the affidavit in opposition. Stop. Next paragraph. The explanation is accepted. 1 week's time is granted to the state to file translated copies of documents sought to be read.
Type
the
copy,
state.
Lordship. Type copy. Type copy, not
Okay,
translate.
translated or
I stand
type copy.
corrected.
Full stop. Same may be filed by 27/11/2024. Next list on 29/11/2024.
Grateful.
Highly obliged, Lordship.
Item 2 for hearing.
Yes.
My lordship. My lord, may I kindly see the impugned order, page 51. But the discussions start from page 52, my lord. And 52, second para, kindly see. In support of her plea, the proceeding opposite party and Muhammad Abdul Sattar Gavura of Honatu village are examined. Supporting her case, the OP adduced evidence as OPW 1 on 8/1/18 stating that her father's name is late Nur Hussain, mother's name is Hajara Khatun, stepmother's name is Mojita Khatun.
None of these names are introduced in the written statement. You find written statement at page 36.
Yes, page 36 written statement.
That there exists a stepmother and all. These things are absolutely new, and therefore then you presented some other document. Jamabandi is of different Jamabandi, but you exhibited a document which
Yes.
is a Jamabandi of 1930-31.
Yes.
Those things are also not pleaded.
My lord, first thing, my lord, one thing is common. Khonatu village is everywhere. Village Khonatu is everywhere. So far in WS is concerned, that is not clearly mentioned.
No, but you are not only there, but you see page 42. That is your evidence, your type copy. Also, you say nothing.
Yes, 42. I am opposite party of this case. My father's name is Nur Hussain. Mother's name is Muhammad Hajara Khatun. Mother's name is Mojida. Stepmother, it will be stepmother's. Name is
Whatever it
Mojida
is, but
Khatun.
you see, you come to page 46. Now this Gaubura does your work. He gives evidence, proves the documents, the annexures. So it is not in accordance with law.
No, my lord, he has issued the certificate and he has proved it.
No, but how could he lay his hand? You see, what business does a Gaubura has to collect exhibit 1, 2, 3, and then prove those voters list? What business does he have?
My lord, Gavura's document is valid so far these cases are concerned.
No, his certificate is valid, but how can he substitute himself for you? He is proving the documents. He can't do that. Under no way a witness, supporting witness can exhibit the documents when you have not. I
My
don't find
submission is-
anything in this case.
that point was perhaps not raised by the prosecution at that time. And it is the settled position of law, if there is any objection in any document, that should have been raised at the earliest stage. So that was not done by them. So that is one thing. Another thing, my lord, I have annexed this land mutation document. The landed tribunal has said, my lord, I am drawing your lordships, kindly see,
Supposing there's a man A, Mr. Mahmood,
my lord.
there's a man A. He goes to the deputy commissioner's office, obtains your land documents, Jamabandi certified copy. Does he become your relative?
My lord, there is a citation,
Any-
Harpal Singh's husband, lordship. আমার অস্তিত্ব
It
রাখি।
says anyone can obtain certified copy and becomes a relative.
No, that is, my lord, in Harpal Singh's husband, lordship kindly see.
What is the
It
citation?
is clearly public document is admissible in evidence
No, please don't confuse
without
public documents.
examining its authors.
No. You see, nobody is saying that you examine the author. My question is very simple. A is a man. He's a man from the streets, and he obtains certified copy of your land documents. Now, by exhibiting it, does he become your relative? Can he lay claim to your property? It's not a question of manner and mode of proof. It's a question of whether the entries in a Jamabandi can make you a relative.
Lord, may I kindly see page 54 for a moment. Bottom, from the, in the cross, he has stated that though of his father expired in 2017, till May 2018, no authentic death certificate has been procured of his father is his first cousin. From the documents available in the record, it is seen that one Jamabandi dated 29/3/16 was issued in favor of the office's father was not proved, and instead thereof has exhibited another document, namely Jamabandi of 1930-31. Honatub and the grandfather of Opi is Shamit, son of Nedu, appears against tag number so-and-so and patta number so-and-so. The certificate copy of the Jamabandi of 1930-31 dated so-and-so has not been proved by the appropriate authority, that is the lawful custodian. So here, my lord, I think the landed tribunal has committed mistake. Lawful custodian is no doubt the circle officer. But to prove that Jamabandi, circle officer need not come. It is a certified copy. And that certified copy, that is a public document, my lord. Now, public document is admissible in evidence as per the earlier section 35 of the Indian Evidence Act, and present section is, I think, 41 of BNSS. 41. So, my lord, that should be believed. So, learned tribunal that not approved, not proved by the approved is lawful custodian. It is not correct finding, my lord, as per the law says, my lord. Now, so far the certificate of Gaura, my lord, Gaura has perhaps visited more area than he was required to do, but that would not make his certificate illegal, because that certificate has the legality in such case. And third one, every time village is Khonatu. But I have a deficiency in this case, my lord, that the other witness should have been examined, at least the nearest relative. That is not done. Perhaps that was wrong advice. Otherwise, Gaura has come, she has come. Another one person could have adduced evidence. That is not done, my lord. So deficiency or less quantity of evidence, at least one or two evidence more should have been given of her nearest relative, but that is not given. And for that, my humble prayer would be, if your lordships are being satisfied, matter may be remanded back, because evidences are less in quantities. And so far the strict proof is concerned, my lord, is this type of cases are not strict proof is necessary. Probability is there because my father's, not only father, grandfather's names are in the 31, 32 Javamundi. 31, 32. It is public document. 59 voter list, my grandfather's name is there. And 65 voter list, my
You see,
grandfather's name is
you have
there.
no documents to show that, apart from the voters list, you don't have any document to show that he is your father or your grandfather. That's why we are asking you a question. If somebody obtains a certified copy of voter list or the land documents of somebody,
So here, my lord, only the Gaura's evidence is there as the linkage with his father, whose name appears in the voter list of 1965. And 65, his father Nur Hussain, his grandfather Shamir, the Nur Hussain's father is Shamir. So that is there, my lord. So far, I am the daughter of Nur Hussain, that has been testified by the Gaura. So your lordships may believe the evidence of Gaura. If that is not considered sufficient, my humble prayer would be to remand back the case, because some more witnesses should have been provided. That is not done. What is not done, I cannot make it done, my lord, at this moment. But
You're relying on this Harpal Singh for what purpose?
Yes, there are several citations, my lord. I have given already the citations before your lordship's court master. So it is 2006, 5 SCC.
No, this Harpal Singh you gave a citation. What is this for?
Yes, surpassing, my lord, that is stated, my lord. Para 3 may be seen, my lord. Para 3, last part. We cannot agree with him for the simple reason that entry was made by the concerned official in the discharge of his official duties. That is, therefore, clearly admissible under Section 35 of the Evidence Act, and that it is not necessary for the prosecution to examine its author. Here, prosecution, here let us read as defense. From whatever angle we view the evidence, the conclusion is inescapable that Soros Kumari was below 16 years of age at the time of the occurrence. Accordingly, we agree with judgment of the courts bureau and see the no merit in this appeal, which is dismissed. Now, it is the ratio of this case is that is therefore clearly admissible under Section 35 of the Evidence Act. So, Lordship may kindly believe this, because there is no only simply that London Tribunal's view was that the author has not come to adduce the evidence. That is not necessary. Otherwise, so many officers in every time a person is challenging the validity of one certificate, then each and every time the controller or secretary should not come. So if it is otherwise believable, that should be believed. And moreover, in foreigner's case, my lord, the preponderance of probability is the standard of proof required for the purpose of establishing citizenship. Now, at least prima facie, there is something that she is the daughter of Nur Hussain. Nur Hussain is the son of Shamir, and Gaura says this Hanufa Bibi, Hanufa Khatun, is the daughter of Nur Hussain. So in that way, there is a channel of connectivity between the three men. Now some more evidences should have been given. That is not given, I think. Lordship is on that point that it may be sent back. Because these are the earlier time of cases, so many lacunas we find.
And what are these judgments in this
Well,
2006 5 SCC? What is this for?
2006, yes, madam.
What is this for?
Yes, that Lordship 2000.
Give us a list.
2006 5 SSC, para 23 and 37.
What is
My
it
lord
for?
may kindly see para 23. I have given.
What does it say? Tell us, what does it say? What point?
It says that Section 35 of the Evidence Act would be attracted both in civil and criminal proceedings. The Evidence Act does not make any distinction between a civil proceeding and a criminal proceeding, unless specifically provided for in terms of Section 35 of the Evidence Act. The register maintained in the ordinary course of business by a public servant. That is very clear, man.
Second case, Abdul Khalik, why you have cited this? Abdul Khalik case, why you have cited that?
Yes, Abdul Khalik means what, my lord? That is para 9 and 10. Here, my lord, the question which are not put to challenge or not disputed at the time of adducing evidence, it should be accepted as admissible. Here, one Gaura has issued the certificate. In that Abdul Khalik's case, I am touching the Abdul Khalik's case, that perhaps one Gaura adduces evidence, and that was not disputed. Therefore, respondent number in 18 memory. Before my landing, sir, so 2 points more. There are some differences in ages and names. So lordships are aware that Abdul Mutali's case and Shirazul has worked. These two cases will cover that there is slight differences because they are rustic people and the enumerators many times cannot write proper name or correctly. So that may be looked into. That is my humble. Abdul Mutali's case and Sirazul Haq's case that will cover. So Lordship is aware about this, so I am not elaborating. All right.
My lord, your lordship may kindly see first the WS, my lord. Yes. Yes. WS, your lord. First of all, my lord, my point is with regard to WS, my lord, page 36. As your lordship has seen already, I'm not inclined to, my lord, read the entire para. But my first point is, my lord, what the petitioner want to prove before the tribunal, that has to be pleaded in the WS first. And what is pleaded in the WS, that is to be proved. Yes. Yes. Definitely, my lord. What my submission is that it's not a normal case, my lord. This is burden is on the proceeding to establish that he is a citizen of India. Initially the my lord, state has cast a doubt on the proceeding that you are not a citizen of India. So, my lord, what the burden, my lord, para 26 as well as the other parts of the my lord, Sobananda Sonowal says, the burden is given to them because whatever, my lord, the knowledge, personal knowledge of the petitioner, it is has to be pleaded in EWS. It is his personal knowledge. Who is he, my lord? Who is his father? Who is his mother? When did he was born? Where is his place of birth? Whether his grandparents, what is the name of his grandparents? These all should be known by the petitioner only, none other than the petitioner, my lord. If he doesn't plead all these things before the tribunal, my lord, what facts he will prove in the tribunal? If your lordship see, page 36, nothing is pleaded. No, my lord, I'm coming to that also, my lord. And my lord, what cross will the petitioner do? The proceeding. In fact, in WS, my lord, evidence also, he has only mentioned about his father and mother's name. When did he was born? That is not mentioned. What about his grandfather? That is not mentioned. My lord, what he has not, my lord, exhibited any documents of any kind of his parents, grandparents, or fathers or mother. Or, my lord, he has not said anything about his sisters, brothers, and sisters. In the evidence also, if your lordship may kindly see page 42, both, my lord, written in a statement as well as WS, my lord. Written statement as well as in evidence, my lord, he has stated nothing. My lord, suppose if a person comes before the court, my lord, say nothing that I am the son of so-and-so or my grandfather is so-and-so. My lord, is it the duty of the state to cross-examine? what is your grandfather's name, my lord? That will definitely not be cross-examined. If he doesn't say that my grandfather name is so-and-so, he was the citizen of India, my lord, there may not be any question on the part of the state, my lord, because he has not disclosed that fact. He has not disclosed anything. But most importantly, my lord, because the petitioner is claiming that she is the daughter of my lord one, who is his father? That is also not mentioned in the WS, my lord. That is very, my lord. My lord, these are the cases, my lord, where there are, my lord, I don't want to generalize, but there are, my lord, cases where they used to pick up some documents of some other persons at the later stage of the proceeding and try to prove it, my lord. At least they have to mention that, yes, my grandfather's name is so-and-so, my father's name is so-and-so, I am the son of so-and-so, I am the daughter of so-and-so. That has to be mentioned, my lord. And I was born at least in this year, I'm not saying anything about that. During this period, from 70 to 75, I was born. It can also be my. But if there is not a single statement, if my lord, state will definitely not cross-examine and find out the, my lord, the facts. If your lordship may kindly see the my lord, evidence at page 42, that is the evidence of the proceeding, my lord. Yes. T-shirt for idea. No, my lord, no. That
Daniel. Standing counsel for the FTN Home Matters, representing respondent number
3, 6, and 7.
3, 6, and 7, and Mr. P. Sharma. Mr. Sharma, we at times we are making mistake. SARMEH. SARMEH spelling. Learned additional senior government advocate appearing for respondent number 5. There's no representation from respondent number 1 and 4. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the legality of the opinion dated 29/5/2018, passed by the learned member, Foreigners Tribunal 3rd, Nagaon, in FT case number so and so, page 51. Next para. No, not next para. Same, continue. By the said opinion, the petitioner was declared to be a foreigner who has entered into the territory of India after 25/3/1971. Next para. We have heard the submissions of the learned counsel representing the appearing sides. Next para. We are on a perusal of the records received from the tribunal. We are surprised to note that there is that in the order sheet of the learned tribunal, between 27/9/2016, when the proceedings was registered, till 29/5/2018, when the opinion was rendered, the presence of the government leader, additional government, assistant government leader, within bracket AGP, is not recorded. Next para. The record further reveals that on 8/1/2018, the DW1 was examined, cross-examined, and discharged, which is also reflected in the order sheet. And on 15/5/2018, DW2 was also examined, cross-examined, and discharged, which is also noted in the order sheet. However, as the presence of the GP/AGP is not recorded, the only presumption that can be drawn by the court is that the learned tribunal had put questions to the DW1 and DW2, which is in consonance with the provisions of section 165 of the Evidence Act. Full stop. However, comma, such questions are recorded as cross-examination. Full stop. Next paragraph. Moreover, comma, from the order dated 15/5/2018 of the learned tribunal, comma, it is noted that on the said date, the DW2, comma, the official witness, comma, who is the Gaon Bura of what is the spelling? Kholatup. Khonatup, KHONATUP village had adduced evidence. He was examined, cross-examined, and discharged. The evidence was closed, and the next date was fixed on 29/5/2018 for orders. Full stop. Therefore, comma, we find that the learned tribunal did not give any opportunity to the petitioner of being heard, either in person or through learned counsel. Full stop. Next paragraph. Therefore, comma, we find that it will be said earlier in consonance with the word in consonance that substitute with these words in a manner akin, AKIN, to the power of the court as conferred under section 165 of the Evidence Act. Huh? That's it. Right. Next paragraph. Next paragraph. As the record of cross-examination of DW1 and 2, in the absence of the presence of the in absence of the GP/AGP,
Thanks to
in the absence of the the cross-examination, the record of cross-examination does not inspire the confidence of the court in the manner in which the proceedings was continued by the learned foreigners tribunal. Stop. This is also not a case where the GP/AGP was present and declined cross-examination. And therefore, to find out the truth, the learned tribunal had put questions to the witnesses. Stop. Moreover, having noted that after the closure of evidence on 15/5/2019, the next date, 18, next date was fixed for rendition of opinion, which gives an impression that no opportunity of hearing was provided to the petitioner, who is To the petitioner or to both sides, to both sides, comma. We find that the court is of the considered opinion that the impugn opinion dated 29/5/2018 cannot withstand the scrutiny of law, and therefore same is set aside as as there was no compliance of there was non-compliance of the principles of natural justice. Full stop. Next, according to the matters, the impugn opinion is so and so, passed in so and so is stage of cross-examination of the witnesses. Next para. In order to compel the appearance of the petitioner before the learned tribunal, or the court is inclined to provide that within 4/12/2024, the petitioner shall appear before the Superintendent of Police within bracket border Nagaon and furnish and along with the certified copy of this order, furnish bill of rupees 5,000 with all those conditions. And thereafter, those conditions are there. Non-compliance, the order will stand revoked. Next para. The petitioner shall thereafter appear before the learned member, Foreigners Tribunal, 3rd, Nagaon, on or before 13/12/2024, and by submitting a certified copy of this order, await for further directions from the said learned tribunal. Next para. In the meantime, the registry shall send back the records of the tribunal. Next para. Before parting with the records, the manner in which the proceedings of FT case number NFT within bracket number 3 bracket closed within bracket capital D bracket closed 313 of 2016 was conducted be brought to the notice of the State Home Department, represented by the his additional Chief Secretary, Home Department,
Principal Secretary.
Principal Secretary, who is represented by the Principal Secretary to the Government of Assam, Home Department. Accordingly, the learned standing counsel for the FT and Home FT Matters and Home Department shall transmit a downloaded copy of this order to the said authority for information and for doing the needful. It is also open to the state to take a call as to whether they are interested in taking up in arranging for training programs for the members of the learned members of the foreigners tribunals, as well as GP/AGP attached to the said tribunal, if deemed fit and proper.
My lord, item 4 may kindly be taken in another day. All right.
Item 3 for hearing.
May I please announce? Let's implement judgment page number 67.
Just a moment. এনকোয়ারিটা against প্রেসিডেন্ট খতম হয়েছে কিন্তু প্রসিডিংস প্রসিডিংস আছে
কিন্তু এটা আমার basically
কিন্তু নোটিশ করতে সেটা এটা করে দিচ্ছে এটা করে দিচ্ছে খবর করেছিল রাতিপুয়া সিক্সটি ওটা এক্সামিন করেছে এটা এক্সামিন আছে 14-3 14-3 প্রসিডিং 14-3 প্রসিডিং 14-3 প্রসিডিং DW2 allowed প্রসিডিং আছে once executive concept like separate করে দিবেন আমরা DW1 সাপোর্টিভ উইটনেস না এটা নিজের কথা বলছি না
কালকে আসা নাই কালি কি
এভিডেন্স না এভিডেন্স না দিলে কি নিজের কথা কয়েছে এতিয়া সেখানে ধরা যে প্রসিডিং নিজের এভিডেন্স নিজের কথা কয়েছে সাপোর্টিং এভিডেন্স দেয় না কয়েক কথা in chief হয়েছে 22 এটি নিজের কথা কয়েছে প্রসিডিং আছে আমার কথা হচ্ছে প্রসিডিং থাকার কথা হইব দুটো তো কি হয়েছে ভোগরা সার্টিফিকেট একটু ক্রস করে আছে ইন চিফ টু সর্ট অফ my grandfather সব নিজের কথা করেছে I have two brothers, two sisters, back and father is so and so. নিজের বসাবো কেন করেছে সব? Intention is not to support the right. It's more to defend himself.
নিজের কথা বুঝেছে এটা তো প্রথমত হিটুয়ে আছে কিন্তু এটা order he is Nilwa is also suspected to primarily
Suspected.
এটা opinion for tribunal opinion tribunal draw করতে পারেন না কিন্তু they have found that notice was not issued no maybe so who is also is suspected বলে করে opinion proceeding draw করে কিন্তু আর কিন্তু proceeding নাই এই যদি মিলিয়ে বলি দেখি আবার মিলে আবার কি করবে হ্যাঁ একটু রাইট হচ্ছে না রং মিলে পৌঁছালে কিন্তু এটু নিজে বগি দেখলে কি হবে evidence on repeat evidence you can say anything
কিন্তু ইয়াতে এই
বিলিটির জন্য ফাদাবিলিটি করে হ্যাঁ অনিকাল মিট কোনো ফাদাবিলিটি করে কি করবো আপনি
এই
নিজে বানাই আমি কি করে
Yes.
My lord, imbued order page number 67, my lord.
Page
67.
A bit louder. A bit louder.
Okay, my lord. Page number 67, my lord, imbued order.
Yes.
yes.
That she is a bona fide citizen of India by birth and that she is the daughter of Rohizuddin Sheikh and Moziron Nessa and was born and brought up at village Bandorkhwa under Sorbok PS of Borbata district. And that she is married to one Dilwar Hussain, son of Niazuddin under Sorbok PS of Borbata district and living with her husband since marriage and so on. The evidence of OP filed in an affidavit as DW1 on so has been perused and taken into consideration, including the statements made by the OP while answering the questions put to her from the bench. My lord, argument was heard on so to answer the reference with an appropriate opinion. I have examined the documents exhibited by the OP which are discussed as under Exhibit A. It is a sale deed, it is a deed of sale in respect of certain area of land situated at village Bandor under Barnagar Circle, registered with the
But you
sub-register.
have not document to connect yourself to your projected parents. There's only a certificate of Gaubura. Gaubura says that when your father was born, he does not know. Then there's a disconnect. How do you connect yourself to your projected parents?
My lord, page number 32, my lord, total list of 1965. Rahimuddin Sheikh, my father.
No, what is the position of law? If somebody gets a voter list
Yes, my lord.
of yours, can we consider him to be a member of your family just because he holds a voter list of you?
No, my lord. I
Then
have no voter list have been annexed with this petition, my lord.
you answer this question only thinking about your own property. You first think about the property you own, then consider a question whether somebody bringing a certified copy of the Jamabandi or voter list becomes a member of your family and can claim share in that property merely because he has a voter list. How do you connect yourself? The only document is your Gambura certificate, and he does not know about your parents.
Our certificate, my lord, page number 43.
43.
43.
Yes, you have seen that certificate. She's an inhabitant in my area.
And my lord, deposition of Gabura, page number 65.
Yes, you see that he doesn't. He says in a cross section he doesn't know about your father, where he was born and brought up. He issued the certificate. The certificate is not disputed. Nobody is questioning the certificate.
Yes, my lord.
But does it prove you to be a citizen of India? That is the question. Because the opinion is of your mother. Mother will claim for her own father. It doesn't make you an Indian citizen because of that opinion of your mother, stepmother.
Mother, my lord. Page
Hmm?
number 38, my lord.
Mother or stepmother?
Mother, my lord.
Mother. Oh.
Page number
So
38.
she will claim from her own parents.
বাপেকৰ মাটিটো আহিব সিহঁতৰ মাটিটো আহিছে নেকি?
65 আছে।
বাপেকৰ মাটিটো ঠিক আছে আহিছে নেকি? দেখুৱা নাই। Reading also has a share in that. Brothers problem. Even after marriage of that.
Exhibit A demolishes your case. Exhibit A is the land of your father. But you are not getting any share out of it. If you don't get a share, that means you are not a member of the family. Because under Mohammedan law, you get a share. Daughter is 1/8. We'll take a short break and come back.
This is only link as my lord, the Gabura certificate. Nothing is there.
You see, it's your evidence. There's no supporting evidence. Your husband also does not give evidence in your favor.
Yes, my lord. Page number 56.
Nobody comes up to accepts you as a family member. The land is also not there. You have brothers and sisters, you are projected, but you don't, nobody came in your favor.
Yes, my lord.
প্রভৃতি অভিযোগ করবে সেটা পরিবহন হবে। কি আছে
এটা 1965
হ্যাঁ শোনা
ভোটার তালিকা রহিমউদ্দিন জায়গা মান
রহিমউদ্দিন
মৌজার ডকুমেন্ট
এইটো
রহিমউদ্দিন বান্দর খাওয়া লোকমান বান্দর খাওয়া ঠিক আছে এবং সাইফুল পারচেজ ফ্রম সাইফুল
ইসলাম
সাইফুল ইসলাম ঘটনা গীতাময় নিপুণ তফসিল বর্ণিত দমফায় পাঁচ কোঠা 5 বিঘা 2 কোঠা 9 লেসা মাটি
জোর পাঠা লিখেছে পাঠা তফসিল
তফসিল কামরূপ জেলার বরপেটা পরবুক থানার অন্তর্গত মহকুমা সাব ডিভিশন পিএস লঙ্কা সকা বাউকি মৌজা লড়পা গাঁও খেরাজ 100 নিয়া পাত্তা কিমান নম্বর 66 নম্বর 2 বিঘা 33 সাগর
ডট নম্বর বহুত আছে
2 কোঠা
66 133 168
133 আছে
which is your first voter list?
There is no photo listing.
Huh?
No photo list is annexed, madam.
No voter list.
Yes, madam. Only Gabura certificate, madam.
not it
Then there's no link. Even your exhibit A, that CLD does not help you then. Because in paragraph 22, you say that 2005 is your voter list. But you do not exhibit that. Page 47, para 22, you say my own name along with husband is recorded in voter list 2005. The voter list is also not there. Therefore, there is no connect.
You mentioned in W. But exhibit B in exhibit is a reason of. You said what happened. But that doesn't prove anything.
That doesn't prove anything.
You can speak. You can speak more good than me. Let's speak more good than me. I don't know. I don't know. The photo to take here. Is that very well again? Huh? Not recorded. Take. Delwar was saying, Ajay. Sajera.
Sajera. Sajera. Thirty.
So the people minus each value. 75 was basically take off. In for book. Book. For book on 1.5. Number 4. Marketing.
এইটাই করেছে, বান্ধবতাই করেছে। But we don't find anything to connect you. You are relying on any citations?
But only one citation, my lord. My evidence has not been challenged by the state, my lord. 2013 1 GLT 941.
What is the citation?
Citation 2013 1 GLT page number 941.
941.
Yes, my lord. Abdul Khalik, my lord.
Only yesterday, incidentally, I found a man. When I was walking in the corridor, he came up and said that, well, he's the new president of India. I told him, I have not heard about you. He said, no, I'm the president of India. I just laughed and he went away. I did not cross-examine him. I did not ask him any questions how he became president. We just found him in the corridor. I acknowledged him as the president and he went away. No cross-examination. Yes.
Lordship has already pointed out, Lordship. One aspect is that Lordship, Lordship,
There's only one aspect here, that the petitioner has a very worse advocate. The advocate could not have been, he does not know anything about advocacy. The one who was in the trial.
Lordship. Lordship, para 5 of the written statement, Lordship, that petitioner.
His brilliance in the advocacy, that is what we took some time when we started this matter. The lawyer's brilliance is evident from the fact that he files a written statement with five proceedings. The notice is only against one.
Yes.
And the tribunal thereafter records that since he is suspected, let a separate reference be registered. So, so that is the starting point of brilliant counsel. So that is one. Second is that there is a land document, and he does not know how to prove the land documents. And then he does not know how to connect the proceeding with the projected father. Sorry, we will not be able to appreciate. Heard Mr. N. Hawk, sorry, Mr. M. Hussain, sorry, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the home and FT matters, representing
and
respondent number 2 and 4. And Mr. P. Sharma, SCRMAH, learned additional senior government advocate, appearing for respondent number 3. And Mr. H. Cooley, learned counsel, appearing on behalf of Mr. AIRE, learned standing counsel for respondent number 5. There is no representation from respondent number 1 and 6. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely Sajara, Sajara Khatun, has assailed the opinion dated 26/4/2018, passed by the learned member, Foreigners Tribunal, Borpeta 11th, Borpeta, in case number, page 67, case number so and so, arising out of PE number so and so. By which the petitioner was declared to be a foreigner of post 1971 stream and liable for deportation. Next para. On receipt of notice of the proceedings, the petitioner had appeared and filed her written statement projecting that she is the daughter of one Rahizuddin, Rahizuddin, one word. Rahizuddin Sheikh, Sheikh, and Mojiran, Mojiran. Next word, Nessa, Nessa. And claimed to be born and brought up at village Bandarkhwa, Bandarkhowa, comma, Moza dash DC Boshi, capital DC, next word, Boushi.
Domka choka bafi.
Oh,
Domka choka.
within bracket, Domka Choka, Domka, Shoka, Boshi, Boushi, bracket closed, comma, PS Sorbhog, comma, earlier district Kamrup and presently district Barpeta. Full stop. She also projects that on attaining marriageable age, she was married to one Delawar, Delowar, Hussein of village Bandarkhwa, in the same village, you said. Don't say Bandarkhwa, in the same village. And she has 4 brothers and 4 sisters. Which are disclosed therein. Post of the petitioner for the projects that her father had purchased a plot of land in the year 1964, white sale deed number 414, dated 1/4/1964. You say the plot of land measuring 5 bigha dash 2 katha dash 11 lecha. In the year 1964, white registered sale deed number so and so, dated so and so. Full stop. It is also projected that in the voter list of 1989, his mother's name was incorrectly recorded. And that her mother was declared as an Indian by the concerned tribunal, wide judgment, opinion dated 18/1/2016, where is that opinion?
My lord, page number 38, my lord.
38.
Sorry, my lord. Page number 67, my lord.
No, 38. We are
38,
38.
38.
You see,
Opinion of
by the Foreigners Tribunal 8th, Borpeta, in FT case number 105/2015, page 38. Full stop. In the written statement, the petitioner has relied on the copy of voters list of 1965, 1970, 1985, 1989, 1997, 2005. The cell deed referred above, elector photo identity card, capitalized first letters, elector photo identity card, and Gaubura's certificate, and copy of Chita. Next paragraph. In order to prove her stand, the petitioner examined herself as DW1 and exhibited the following documents. Certified copy of registered sale deed number 414 dated 1/4/1964 within bracket exhibit A.
Certified to the 215.
2021. Obtained on 25/11/1995. Certified copy of the voter list of 1965 of her projected father and mother within bracket exhibit B, certified copy of voter list of 1970 in the name of her projected father and mother within bracket. This is stepmother. Father and stepmother within bracket exhibit C. Voter list of 1985 containing the name of his projected father, projected stepmother and projected stepbrother. 85. This is not, strike it out. This is not there. Strike it out. After C, 1985, strike it out. It will be 1989. Voter list of 1989. Purportedly containing the names of his parents, stepmother, stepbrother, step sister-in-law, and claims that her mother's name was mistakenly appearing as Marijan, Marijan, Nessa, instead of Majiran, Majiran, Nessa. Within bracket exhibit D, and opinion dated 18/11/2016 in FT within bracket Roman 8 bracket close 105 of 2015 within bracket exhibit E. Just elected a copy of No, not copy. It's elector photo identity card within bracket exhibit F and certificate of Gambura of Bandarkwa, Bandarkhowa within bracket exhibit G. Full stop. In support of a stand comma, the petitioner has also examined one Dilawar, Delowar, Dilawar Hussain as DW2 yes, DW2 only two. And the first of, however, on a perusal of the record, it appears that the DW2 has not exhibited any document, comma, 7 except a certificate issued by the Gambura of Bandarkhowa claiming to contain linkage of the father of DW2 as well as his wife, comma, i.e. the petitioner. Full stop. He had also examined, sorry, she has also examined one Basishto Talukdar as DW3 comma, who is the Gambura of where is the document?
My lord, page number 43, my lord. Vernacular page number 43.
Gambura Niz Domka. Gambura
Niz Domka and Bandarkhowa.
Nishkwa Bandarkhowa. Under charge number 23. Next paragraph. The learned tribunal where's the opinion, which page?
Page number 67, my lord.
Upon scrutiny of the evidence and pleadings on record, the learned tribunal had held that there was no document on record by which the petitioner had conclusively proved that her recorded father, Rahimuddin, Rahimuddin, and projected father Rahimuddin Sheikh SK. Spelling of Sheikh is SK. Son of Lukeman, Lukman, is one and same person. And it was held that there is no document which links the petitioner with a recorded father or projected father. And accordingly, it was held that the earlier opinion, within bracket Exhibit E, by which the petitioner claims her stepmother, Majiran, Majiran, Nessa,
Being stepmother. যাতে করলেন যারা পেতেন stepmother. Mother was a model on this.
CBD, no?
Page, you come to page 45 first. Page 45. 45 first line. And origin nessa. Okay. That's next page. There are 5 and there are 6. There are no stepmother. So to it was her own mother. Clean mother. It will link it there. Link it. So I mean, people more.
And it was held that this said opinion within bracket Exhibit E was not relevant to decide the reference against the petitioner. Full stop. Insofar as Exhibit E is concerned, we take note of the statement made by the petitioner in her evidence on affidavit, filed as DW1, wherein in paragraph 1, she has stated that she is the daughter of late Rahiz Rahiz Uddin Sheikh Sheikh, and Mojiran 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 Nessa Nessa. And in paragraph 5 thereof, she has stated that Hazira Hazera Khat Majiran Majiran Nessa is not the stepmother, but the mother of the petitioner, projected mother of the petitioner. Full stop. However, there's no other link document to connect the petitioner with her projected mother. The learned tribunal had held that the petitioner had failed to discharge her burden of proving that she is not a foreigner, and the reference was answered in the affirmative. Next paragraph. The learned counsel for the petitioner has submitted that the stand of the petitioner in her evidence on affidavit remained unquestioned about the veracity of her claim to be the daughter of late Rahizuddin, Rahizuddin Sheikh. And Mojiran, Mojiran, Nessa, who are claimed to be the projected father and mother of the petitioner. So accordingly, committee submitted that as the said evidence was not challenged. The opinion rendered by the learned tribunal was contrary to the decision of this court in the case of what is the name of the parties 2013?
Abdul Khalik versus
Abdul-
Union of India.
Abdul Khalik versus Union of India and others, within bracket 2013. No, not in bracket, say 2013 within bracket 1, bracket close GLT 941. So accordingly, it is submitted that the petitioner has been successfully able to link herself to her projected parents, and therefore it is submitted that the impugned opinion be set aside. Next para. We'll have to rise. We'll continue to. We may be late by 5 or 10 minutes while resuming. What was the last sentence? एक मिनट पढ़ लो last follow me. Where was I last when I left?
My lord.
When I left, what was the last recording we were making? Which what were we dictating? Last when we were dictating, what was that?
Lordship was discussing, I think Lordship was discussing as regard judgment of the mother Lordship.
Judgment of?
Mother, projected mother Lordship. Page 38.
Okay. Oh yes. Just come down. We'll start from there. Just make a note that there is a gap here. Huh? Then we'll continue. be that as it may, as the next. Now, in order to examine as to whether the petitioner has been able to discharge the burden of proving that she is not a foreigner, but she is an Indian citizen and born out of the wedlock of parents who are citizens of India. The petitioner has exhibited 7 documents as referred above as exhibit A to G respectively. Full stop. Insofar as the sale deed is concerned, which is exhibit A, it establishes that the that one Mohammed Rohimuddin Sheikh, Rohijuddin, son of late Lukeman, Lukman, Sheikh of village Bandarkoa under Moza Domka under had purchased the land from its vendor on by the said sale deed which is registered on 1/4/1964. Full stop. In respect of a plot of land measuring 5 bigha 2 katha 11 lacha, which is more fully described in the schedule to the said sale deed. Full stop. However, there is no document full stop. However, contrary to the contents of the opinion, from the document which is marked as Exhibit A and proved in original, which is available on record, it is seen that they said Exhibit A is a certified copy and it's not an original sale deed. Full stop. Full stop. Therefore, the mere availability of a certified copy of a sale deed with the petitioner does not establish her despite that her father is the person who had purchased the land by the said sale deed. Full stop. The vendee of the said sale deed or his other legal representatives were not summoned to give evidence to link the petitioner with the vendee of the said sale deed. Full stop. Next one. Although the learned counsel for the petitioner has laid stress on the point that as the evidence of the DW1 was not cross-examined or demolished, that she is the daughter of one Rahijuddin Sheikh, but the court is unable to accept the same on the ground that in order to prove a sale deed, the original sale deed should have been exhibited or the petitioner should have demonstrated that demonstration why recourse to section 65 of the Evidence Act was taken recourse to, and not by exhibiting the primary evidence within the meaning of section 62 of the Evidence Act. Full stop. Next para. Next para. A mere holding of a certified copy of a voter list or a certified copy of a sale deed would not be a sufficient discharge of burden of the proceeding in a case of determination of whether or not the proceeding is a foreigner, as per the requirement of section 9 of the Foreigners Act, 1946. Next para. Therefore, Exhibit B, C, and D, which are the voter list of 1965, 1970, 1989, is not a sufficient link to establish that the petitioner is the daughter of her projected father, I. Rahizuddin, Rahizuddin. Full stop. In respect, next para, in respect of Exhibit E, the certified copy of the opinion of the tribunal in the matter of Marijan, Marijan Nessa, was declared not to be a foreigner in FT case number 105 of 2015, is already discussed above and discussed above that the said proceeding was the mother of the petitioner, or projected mother of the petitioner. Full stop. However, there is no other document to link the petitioner to a projected mother full stop. We also take next paragraph. We also take note of the fact that although the petitioner has projected in her written statement about her own family and the projected father, but none of the members of the family of her projected father gave evidence to support the claim of the petitioner to be a member of their family and deriving her lineage through Rohizuddin, Rahizuddin, Sheikh, and Morijan, Morijan, Nessa. Full stop. Next, coming to Exhibit F, which is the elector photo identity card. Full stop. There, instead of comma, there are catena of judgments which have wherein it was held that EPIC EPIC is not a sufficient proof of citizenship of its holder. Full stop. If one requires an authority on the point, comma, the judgment of this court in the case of yes, that EPIC card is not a
Babul Islam.
Huh?
WBC 3547 of
What is the name?
2016. Babul Mohammed Babul Islam.
Just write it and give it.
Yes,
Just write in a slip and give it.
yes, Lordship.
Gap, that judgment will be added here. Next para. This leaves us with the certificate of the Gaupura, which is marked as Exhibit G. Full stop. On a perusal of the records of the tribunal, comma, it is noted that the document marked as Exhibit G contains state emblem, printed state emblem of the pillar of Asoka, ASOKA, printed on the said document. Where is that? Which page was that?
That page number 44.
44.
Gabra Stadium.
No. No, I'm sorry. Don't write that. It's a mistake. It is a so-and-so. Full stop. In this said regard, we find that in the cross-examination, here we'll stop there. There's a document of Exhibit 6, Exhibit G, only there. Till there, stop. That leaves us with Exhibit G, full stop. So in this regard, we find from the from the examination of the Gaura, which is DW3, comma, he has stated that he is not aware as to when and where the parents of the proceedee was born and brought up. And he had issued the certificate as per the requisition made by the petitioner. Full stop. Therefore, comma, although the projected father of the petitioner is from the village Bandor Khwa, BANDAR, which is within the charge of the DW3, his certificate is not based on personal knowledge of about the projected father of the petitioner, but is issued at the calling of the petitioner. Full stop. The said certificate is in respect of the address of the petitioner and cannot be accepted as proof that the name of her projected father stated therein, i.e. Rohij, R-H-I-Z, next word Uddin, U-D-D-I-N, is the same person whose voters list whose certified, or whose names appear in the certified copy of the voters list, which are exhibited as exhibit B, C, and D, or that it has any link with the petitioner. Full stop. Next para. Accordingly, we find no good reason to interfere with the opinion impugned in the present writ petition. So according to this, writ petition fails and the same is dismissed. So the consequences thereof shall follow. Next para. The records of the tribunal be returned back. Next para. There shall be no others to cost. There will be some corrections because I missed that in between.
Most of the time.
There was a disconnect, so let's try to connect the dots. Mr. Gowri, you're sitting for the next division bench. That will be left over. We'll fix another date. The registry will do it. Please inform other council over there. Will be rising. It will be.